Good afternoon, everyone. Thank you so much for joining us today. If you do have questions or comments, we're able to see the Q&A, so feel free to submit your Q&As there. So thank you all so much for joining us today. If you are someone going through family court issues and are seeking guidance and information, welcome. We're so glad that you're here. If you're a service provider or an advocate or just interested in learning family law, welcome as well. We are thrilled that so many of you can join us today. Next slide, please. First, want to do quick introductions. My name is Jessica Stadmeyer, and I'm the Director of Legal Resources and Community Engagement here at Family Legal Care. I'm also one of our attorneys on staff, and I'll pass it over to my colleague, Molly, to introduce herself.
Hi, everyone. My name is Molly Burke. I am also a staff attorney here at Family Legal Care, and I am also the Advocacy and Policy Advisor.
Thank you, Molly. Next slide. So before we get to our presentation today, you may have heard or noticed that we have a new name. LIFT is now Family Legal Care. All of our programs and services, which we will go over today, have remained the same, but we're really excited because we think that our new name, Family Legal Care, better conveys who we are, what we do, and the heart of our mission, which is to provide compassionate support and care to families who are going through the New York State family court system, and ultimately to help increase access to justice. So we hope that you all are as excited about our new name as we are. Next slide. Just a couple of housekeeping items before we get started. We really want this webinar to be interactive. So here are some ideas of how you can participate. If you haven't already done so, if the chat's working, please say hi and introduce yourself. If not, say hello in the Q&As. We'd love to hear from you. And throughout the presentation, we will be asking a series of poll questions. Please participate. We'd love to hear your responses and your thoughts on the presentation. We will be stopping periodically to ask for questions and also to save some time for questions at the end. But as we're going through the material, please submit any questions you have through the Q&A button at the bottom. I do know that's working because I've been seeing some Q&As coming in. And then finally, I'm going to try to turn on the chat in just a little bit. So if you have any comments or questions that come up during the webinar, feel free to submit those there once it's up and running, if I can get it running. And I apologize for the tech issues. Next slide. Okay, so now to our first poll. Just one second. Okay. All right. Give me one second. Sorry, apologize. Okay, here we go. So what brings you here today? Please take a moment and select the option that best represents you. Looks like some answers are still coming in, so I'll give it another 30 seconds or so before I close the poll. Okay, thank you all so much. So we have a nice mix of people here today. We have about 9% are parents or caregivers. The majority of people here are partners or advocates looking to help your clients. And then we have some people who are just interested in learning about family law, which is great. And then we have some people who are here for another reason. So thank you all. Next slide. Okay, here's what we're going to cover today. First, I'm going to talk about Family Legal Care's programs and services, including how to reach us if you or your clients need support. And then I'll give a really brief overview of family court before I turn the presentation over to Molly. Molly will be covering our substantive law topics today, including paternity and parentage, child support, custody, visitation, guardianship, and then orders of protection. As we're discussing these topics, I just want to note that all of the material covered here today is intended to be legal information only and not advice. So as I mentioned earlier, we encourage you to submit your questions using the Q&A feature below, but you may hear us at some points tell you to contact our helpline or to speak with a lawyer, either from Family Legal Care or elsewhere, for more specific legal advice. And that's because every situation is different. So what applies to one family may not apply to everyone. Next slide. And on that note, we're going to get started. So here's an overview of what we do and who we are. If you're not familiar with family legal care, our story goes all the way back to 1996, when a group of 3 young lawyers fresh out of law school recognized there was a real need in the New York family court system for people just to get basic legal information. They set up a folding table in the Manhattan Family Court and stationed themselves there to answer questions and offer guidance to anybody who walked up. And over 25 years later, our organization has really grown, but our mission remains effectively the same, which, as I mentioned earlier, is to increase access to justice for families in New York Family Court. Today, we do this by offering parents and caregivers free legal information and advice, as well as easy to access resources and technology to help people navigate the family court system, not just here in New York City, but also all over the state. Next slide. Our helpline gives information about New York family law and family court procedure by phone, live chat, and email. Our helpline is also an entryway to our services. So if someone is interested in meeting with one of our lawyers, which I'll discuss in just a minute, our helpline associates will conduct a screening to see if that person's eligible for a consultation, and then we'll go ahead and schedule that appointment. I will say, though, that often people find after contacting our helpline that they get the information that they need to figure out their next steps. Our helpline associates are amazing and can give people a whole wealth of information or point them in the right direction. Our general helpline numbers are what you see here listed on the slide. So Monday through Friday from 9 to 5, though we do close for lunch from 1 to 2. And the phone number for the helpline is listed here, 212-343-1122. But you can also access our helpline through live chat and email on our website, familylegalcare.org. And we'll put this information in the chat and share it at the end as well. Next slide. Family Legal Care offers limited scope representation. That means that we have a team of staff attorneys, such as myself and Molly, and pro bono attorneys who meet with unrepresented parents and caregivers for 1-hour consultations, either by phone or video. Unrepresented means that they do not already have an attorney representing them in their case. The level of support our attorneys provide during these consultations really depends on the case and the litigant's needs. And when I say litigant, what I'm referring to is someone who has a case in court. Examples of what our lawyers can do are provide legal guidance on next steps, help litigants prepare and file petitions or motions, and advise litigants on how to effectively represent themselves when they go into court. Depending on the case, our attorneys may also be able to provide follow-up consultations and follow-up support as needed. So if you or someone you know that's interested in a consultation, you can visit our website to learn more or reach out to our helpline. Next slide. It's important to note that we do not have any income requirements for our services. All of our services are free. For a consultation, the only requirement are that a litigant is not already represented by an attorney, that the case is one of the types of cases that you see listed here, and that the case is in New York Family Court. So as you see, we provide consultations on paternity and parentage, child support, custody, visitation, and guardianship. We can also advise people regarding domestic violence issues and orders of protection as they relate to the issues that you see listed here on this slide. We do not, however, provide advice on divorce, which is handled in Supreme Court, not in family court. And we also do not provide advice on abuse and neglect proceedings. Next slide. Family Legal Care also offers over 60 original legal resource guides, which provide step-by-step information on a whole range of New York family law topics and court procedure. The guides are available in 9 different languages and can be found on our website at the URL you see here. And I'll just note that we have a new website that we just launched last month, and this website is, we think, really great, and it makes it much easier to search for legal resource guides by topic, language, and location. And also another quick note, we're in the process of redesigning our legal resource guides. So if you are familiar with them, you may notice that they look a little bit differently than what you're used to, but we think the new guides have a lot of great features and a much more simple and accessible layout. Next slide. In addition to the other programs and services, we offer free tech hubs. During the pandemic, so many of our services moved online, including the family court. Many family court hearings are still virtual, and litigants can now, which is great, file petitions and other documents electronically. However, as we all know, not everyone has access to a computer or a printer or have reliable internet. So at our tech hubs, litigants can access technology and receive assistance to attend virtual family court hearings, download and submit forms, and navigate the online court system. We currently have 2 tech hubs open, one in Brooklyn at the Family Legal Care Office, which is right by Brooklyn Borough Hall, and one in Queens at the Legal Hand Office, which is right by the Family Court. You do need an appointment, so the email address and the number to make an appointment at our tech hubs are listed here, techhub@familylegalcare.org, and the number is 646-893-5874. Next slide. And lastly, through our Family Law Navigator tool, parents and caregivers can answer questions about their particular family law situation and are given a detailed, customized report with next steps they can take, including links to forms and petitions to fill out. The tool is available on our website, familylegalcare.org/navigator. And on our website, we also have links to common court forms, including guided court forms that walk you through completing certain family court forms and that generate a completed document in PDF format at the end that's ready to be filed. These are really great because they walk you through the process and the questions and make it simple for you to fill out these forms. So definitely check them out. And now I'm just going to give a really brief overview of the family court system. And before I do that, I'm just going to reiterate again that all of our services and programs at Family Legal Care are free, regardless of your income. So please visit our website at familylegalcare.org to learn more. Next slide. So before Molly gets into all the substantive law topics, I just want to lay a little bit of groundwork on the family court system in New York. So in New York, the family court hears and decides certain types of cases, which are the ones you see here. The ones in green are the types of cases that family legal care attorneys can advise on. And remember, again, in New York, divorce is not handled in family court, it's handled in Supreme Court. And then finally, you should know that every county in New York has its own family court. Next slide. Family court in New York is intended to be a pro se court. Pro se means unrepresented by an attorney. And so what this means is that family court is intended to be more friendly and accessible for people who do not have an attorney. There are no filing fees and rules are supposed to be more simple. In fact, most people do end up going through the family court system without a lawyer. So if you or perhaps a client is dealing with a family court case, that person may be able to get a lawyer assigned to them at no cost. It depends on the type of case and on the person's income. We're going to go over that a little bit more today, but if you have questions, just feel free to reach out. And please know that you do not need a lawyer to start a case in family court. You have the right to file petitions and start cases on your own. That's where Family Legal Care can help. So with that, I will turn it over to Molly.
Thank you so much, Jessica. So let's start by talking about paternity and parentage and what that is. So what's the difference between parentage and paternity? Paternity is the status of being a legal father. Parentage is the status of being a legal parent. And the law recently, last year, shifted to parentage in New York instead of just paternity. So it's now more inclusive after this act, the Child Parent Security Act, or CPSA, was passed. This law, among other things, allowed same-sex couples to file to establish parentage in family court. And what it really does is expand the definition of parent to be more inclusive. And we'll talk a little bit more about the CPSA in a little bit. I will say that a lot of people still use the term paternity, but for this presentation, I'm going to use the more inclusive and the updated version term of parentage. So you'll often hear from the court or lawyers about establishing parentage or paternity, and what this really means is determining or proving who the legal father or parent of the child is. And parentage has to be established legally before any custody, visitation, or child support can be heard in court. Once it's established, parents have equal rights to their child. So now let's talk about how parentage is established. We're going to use Maria and Robert as an example of how to understand parentage because it can get a little bit complicated. So the first way is through marriage, or what's called the presumption of legitimacy. This means that whoever is legally married to the mother of the child at the time the child was born will automatically be considered to be the legal parent. Parentage doesn't have to be established in court. So for example, if Maria and Robert were legally married at the time their child was born, Robert will automatically be considered the legal father of their child, the legal parent. The second way is through what's called an acknowledgement of parentage, or an AOP. Whoever signs the AOP, this acknowledgement of parentage, is considered the legal parent. And this is a form filled out by both parents stating that the individual filling out the form is the parent of that child. So if Maria and Robert were not married and Robert signed this AOP, Robert will be considered the legal parent or legal father of this child. The third way is through a court order or an order of filiation, which is essentially saying an order of parentage. This is a court order entered by a jurist, usually by a support magistrate or a judge after a parentage case is filed in court. The jurist can enter this order when the parents either consent or agree that the other person is the parent of the child, or after a genetic marker, a DNA test, is ordered by the court. But you should know that any old DNA test is not going to work. It has to be a court-ordered DNA test. So for example, this would work if Maria and Robert were not married, Robert never signed this AOP, a jurist could issue an order of filiation. Now we have equitable estoppel here. This is something that can prevent someone from challenging paternity, and it can get extremely complicated. So for example, if Robert was holding himself out or acting as his child's father, he will be considered the legal father, or could be considered the legal father. The court would prevent him from challenging paternity. Again, this is something that can get extremely complicated. So give us a call if you have any questions about equitable estoppel. Now, who can file for parentage? A lot of people, as you see, and a lot of people that you may already know or think about. So the biological mother, the alleged biological father, child, the child's guardian or caregiver, but also the Department of Social Services, or DSS. If a parent or caregiver has a child listed on a budget letter for their public assistance case, DSS can automatically file a parentage and child support case, and we'll talk about child support in a little bit. You can also file, if you're an intended parent. And again, this can get tricky, but as I mentioned earlier about the CPSA, that's the law that allows parents to establish parentage, even if they're not necessarily the biological parent of this child. So for example, in instances of gestational surrogacy. Now, like I said before, once parentage is established, once it's decided in court, you have all the same rights and responsibilities as the other parent. So now let's talk about child support. What is child support? Child support is essentially the financial support provided by the non-custodial parent, the parent who doesn't have custody, to cover general expenses like food, shelter, clothing, those necessities, and also includes add-ons, expenses for healthcare, health insurance, and childcare. So let's go over some frequently asked questions that a lot of our litigants will ask or will call on our helpline and ask. So how long does child support last? In New York State, child support goes until the child is 21 years old. If a case is going past 21, there could be arrears or unpaid child support, which we'll discuss in a little bit. Will the court decide custody and visitation with my child support case? No. In New York, child support and custody and visitation cases are heard by separate jurists. So the cases don't affect one another, and they'll be heard separately. Can I get a court-appointed lawyer to represent me? Generally, there's no court-appointed lawyers for child support. And this is unless you are in a violation case and you are at risk of potential incarceration. We can talk about that in a little bit as well. So I mentioned before about DSS filing. If there's a child listed on the budget letter for parentage, they can also file for child support. So what happens if a child is receiving public assistance? DSS, the Department of Social Services, is automatically going to start a child support case against that non-custodial parent, the parent who doesn't have physical custody. Now, if you have any concerns about domestic violence, You should speak with your caseworker when you're applying for benefits, and they may be able to talk through some different options when it comes to filing for child support or DSS filing for child support. So how does the court calculate child support? Well, they generally try to base it off of the party's actual income, but this only happens when, one, the parties appear, meaning they're showing up to court, including virtual court, on time, and they're seen by the support magistrate, the person who's overseeing the child support case. And two, they have to provide credible or believable evidence, meaning you have to provide your financial disclosure affidavit, pay stubs, bank accounts, evidence about your income. Now, child support is retroactive, meaning it goes back to either the day that the custodial caregiver, the person who has physical custody, either files a petition for child support or when the child goes on public assistance. It does not go back to the child's birth. Now, with child support being retroactive, this often results in arrears or unpaid child support automatically being added to a child support order. And that's often paid off incrementally per order. So what that looks like generally is half of your order will be added to the current order until the arrears are paid off. If you're providing support to the custodial parent or caregiver from the time that the case started in the form of financial payment, you may be able to lower your arrears by getting a credit. And you'll want to submit evidence of payments, Zelle, money orders, Venmo, things like that, to the support magistrate to get this credit. Now, child support can be broken into two parts. I talked in the beginning about necessities. This is the basic obligation to cover the basic needs of the child: food, clothing, shelter. Really think about this as necessities. And secondly, add-ons for unreimbursed medical expenses, childcare, educational costs. Now, I get a lot of questions about educational costs for college. It does not include college. This is for things like after-school tutoring, potentially college prep courses, but not college itself. If college is going to be included in child support through the court, the parties must agree on it beforehand. We also have the chart here. This is what the court uses to calculate child support. They're basing it off of your income, and they have a set of guidelines, a percentage to apply to that combined income. So now let's do a poll. True or false? Child support arrears, the unpaid child support, go away when a child turns 21. True or false? We'll give you just a minute to answer that poll. Okay. And if I can get the results. False. Yes. 90% of you are correct. False. Child support arrears never go away. These arrears are unpaid child support, and it's extremely difficult to change those arrears once they're in place. Now, if you owe those arrears to the custodial caregiver, the person who has physical custody of the child, only they can forgive those arrears. If the child is receiving public assistance, the arrears are owed to DSS, the Department of Social Services. And you'll want to contact OCSS, the Office of Child Support Services, to talk about your case and see if you qualify for any of their arrears reduction programs. They often have different programs that you may be able to talk to them about lowering those arrears. And because it's so difficult to modify or change those arrears, it's so important to file a modification petition as soon as there's been a substantial change in circumstance. So let's talk about what that is and how to modify your child support order. A modification petition is just asking the court to change a final child support order. Now, to do that, you have to prove one of three things. One, that either parent's income has changed by 15% or more. Two, that more than 3 years have passed since the last court order. Or three, there's been a substantial change in circumstance. That means it could mean a child moving in with a different adult, an emancipation event, meaning the child joined the military, they got married, there's more than one child on the order and the older child turned 21. Incarceration, change of employment, someone lost their job. Now, when considering whether to modify or change that court order, the court is going to want to know the reason why the job was lost. And the court is going to want to know the reason the job is lost because they're going to try to make sure that it wasn't a voluntary change of employment and that the person who lost their employment is looking for or has found a job at the same or similar income. Now we have at the bottom, please know that the court can generally only modify the order back to the date that the petition was filed. So again, you're seeing the court is limited with what they can do. They can only go back to the date a petition was filed. So it's important to file as soon as possible. And I also mentioned to reach out to the Office of Child Support Services, OCSS. They help parents and guardians with child support. They're the ones who are enforcing the child support orders. They can help file for child support, locate a non-custodial parent, collect child support payments, enforce them. And they also have other services for both custodial and non-custodial parents. So please email the email you see here or call them at 1-888-208-4485. And I believe Jessica will put that in the chat. So know your rights. A parent has a right to visitation, even if they're not paying child support. Like I mentioned before, child support and custody and visitation are separate cases heard by separate jurists in New York. If you're not paying child support, you still have a right to visit with your child. I'm going to pause there and see if we have any questions about parentage, paternity, or child support.
Molly, we did have a couple of questions come in about parentage.
Sure.
First question is, can a husband challenge the presumption of parentage?
Yes, they absolutely can. This can get extremely tricky. So I would say it's something to contact us about that we can provide more individualized advice on. And you're going to hear me say, it depends a lot. And that's because every single case is different. And we don't want to provide any legal information or advice to one party when it may be different for another.
Thank you, Molly. And another question came in about birth certificates and how that works with parentage, particularly with the acknowledgement of parentage form. Could you talk about that?
Sure. So the birth certificate, what I'll say is birth certificates can change. You can add a parent to a birth certificate in family court after a parentage case has been filed. If it's after a parentage case has been filed or you're past that point, or a child is over 21, something like that, you would have to file in a different court, either surrogates court or Supreme Court. We have a really great legal resource guide, or LRG, on our website about changing the name of your child or changing the name of your child. And I would encourage folks to check that out.
As a follow-up to that question, is being on a child's birth certificate enough to establish paternity or parentage?
No, you would have to establish it in one of those three ways that I mentioned: through marriage, the presumption of legitimacy, through signing that acknowledgement of parentage. The acknowledgement of parentage, the AOP, and the birth certificate are separate documents. So signing the birth certificate could indicate that someone may be a legal parent, but you would still have to either sign the AOP or get a court order affiliation if you're not married.
Thank you, Molly. I believe those are all the questions about child support and paternity and parentage. We do have a question that would be a good segue for our next section. So
Sure.
This person's question is about visitation rights. What happens if a non-custodial parent constantly doesn't show up for their parenting time? Is there a penalty? And also, what happens if child support has not been paid for over a year?
Let me take the what if child support has not been paid for over a year. The custodial parent or whoever is owed that child support can file an enforcement petition in family court or whichever court issued that order or entered that order. For visitation, I'm actually going to talk about custody and visitation right now, so I hope it will answer your question.
Before you do, we just got a couple more questions about child support, if you could answer
Sure.
these quickly. So if a mother used to live in New York when the child was born, and the child was also born in New York, but now the mother has moved to Florida and is seeking child support, but the father still lives in New York, how would this work?
So you could file in Florida or New York. Child support you can file in Florida or New York. It depends on either where the child lives or where the non-custodial parent lives is where you can file. But again, that can get a little bit tricky, so call us for more specifics.
And then I believe this is the last question about child support. Does a non-custodial parent who is earning less than the custodial parent still have to pay child support?
Potentially. If they are the non-custodial parent, they do not have primary physical custody, and we'll talk about what that really means in a minute, then yes, they are obligated to financially provide or pay child support. All right,
We had a couple more questions coming in, but we'll save those to the end. So if you want to
let's save those to the end. Great. All right, so let's talk about custody and visitation and what that means. Custody is really the right to parent your child, and there's physical custody where the child lives, and there's legal custody, meaning the ability to make major decisions that impact your child's life, things like education, medical and healthcare, religious decisions, things like that. And visitation is parenting time between a non-custodial parent and their child. Whoever doesn't have primary physical custody generally has visitation. Now, there's a number of domestic violence considerations if there are domestic violence concerns involved. And what this can look like is public spaces for pickups and drop-offs, for example, a police precinct, local library, things like that. And the court may order limited communication, for example, communication by email or text only or a certain app. So that's something you may be able to ask the court for as well. So let's talk about the types of custody. And we're going to bring back Maria and Robert to help us explain this. So there's joint custody, meaning both parents share legal decision-making or parenting time, or both. So what this can look like is Maria and Robert's child, they have a child, Zelda, and Zelda lives with both of them. Maria and Robert both have decision-making power. There's sole custody, meaning one parent has more decision-making power or parenting time than the other. And what this could look like is Robert has sole physical custody of Zelda. Zelda lives with Robert. There's also split, or sometimes referred to as zones of decision-making. And this could look like Robert having decision-making power over educational decisions, while Maria has decision-making power over medical decisions. And there's also shared custody. This is the default. This is what happens when people have no court orders. They have shared custody once parentage is established. So it's also important to know that these types of custody can be mixed, and they're really determined based on what is in the best interest for each family and what's in the best interest of each child. So for example, you could have joint physical custody and sole legal custody. And as you can see here, there's a number of different types of visitation. There's supervised, and this can be through an agency or a private neutral third party. There's unsupervised, there's therapeutic, meaning through a therapist. There's daytime, overnights, electronic or telephonic. Electronic and telephonic were really big at the height of COVID pandemic. FaceTime visits, things like that, those were electronic and telephonic visits. So let's do another poll. What age can a child decide custody in New York? 12, 14, 15, or none of the above? I'll give it another minute. Again, at what age can a child decide custody in New York? 12, 14, 15, or none of the above? All right, and the response is 54% of you said none of the above, and you're right. So what the court is in New York, there's no magic age at which a child is going to be able to decide custody. The court is going to look at what's in the best interest of the child. This is a standard. So what this looks like is a number of factors that the court is going to look to determine who should have custody of this child. They're really looking at the stability for the child. They're looking at who's been the primary caretaker, who's been taking care of this child for their entire life. They're looking at the quality of the home environment. Does one parent live in an area surrounded by other family and friends? The ability to provide for a child's emotional, intellectual development, the relative fitness of each parent, mental health, substance abuse issues can come into play, the desires of each child. What the child wants will be a factor. It's not going to be the only factor that the court considers. And any other relevant factor that the court sees fit. Now, who can file for custody and visitation? This is known as standing. Someone can file if they have standing. Parents can file after parentage has been established. Grandparents and siblings can also file. And they can file if there's a reason why visits are not happening through the parents. There has to be an established relationship between the relative and the child, and it's always got to be in the best interest of this child. And that's for visitation. For custody, the legal parent or a non-parent caretaker if there's extraordinary circumstances, and it would be in the child's best interest. Again, best interest standard. Now, it's very hard to take away a parent's right to custody. Generally, the court's not going to disturb a parent's right to file for custody unless there are extraordinary circumstances. For example, a child protective proceeding. And again, always looking in the child's best interests. We're going to do another poll. We've gotten a lot of questions about relocation. So if you want to relocate with your child, you must have a court order. True or false? If you want to relocate with your child, you must have a court order. True or false? Okay, and the results, please. Pretty evenly split here. 44% true, 56% false. Let's talk a little bit more about relocation. So this is kind of a gray area. Relocation, the custodial parent, whoever has primary physical custody of the child, may need permission of the non-custodial parent, the parent who doesn't have custody, or the court before they're moving. The court is looking at, again, what's in the best interest of the child. And there's this balancing test from a case called Tropea that set out a number of factors, more factors that the court is looking at. The court is going to want to know things like the reason for the move, how it's going to impact the relationship between the child and the other parent who isn't moving, and the stability of the child. Those are all going to be factors when the jurist is determining whether or not someone can relocate or move with their child. Now, it's important to know that if a parent relocates without a court order or written permission, the other parent has 6 months to bring them to court in New York. Otherwise, the other state may have jurisdiction or authority to start a case there. Now let's talk about frequently asked questions that we get with custody and visitation. Where can I file for custody and visitation? This depends on where the child has lived for the past 6 or more months. That's why when I talked about relocation, you have 6 months, less than 6 months to file for custody or visitation before that other state may have jurisdiction or authority to hear that case. How do I change my custody and visitation order? Again, you would file a modification petition like a child support order. Similar to custody and visitation, it's a modification petition. You must prove that there's a substantial change in circumstance and that it's in your child's best interest to modify the order. How do I enforce my custody and visitation order? You would file a petition for enforcement or violation petition in family court. This could also be to enforce your custody and visitation order. A violation petition could also be the basis for modifying or changing the court order. And you should also know that the court cannot force a non-custodial parent, the parent who doesn't have physical custody, to visit with their child if they don't want to. Can my child testify in court? Generally, no. The court's not going to want children to come into court. How the court gets around this is by appointing a lawyer for your child to represent them and what they want in court. Now, Jessica talked at the beginning about having a lawyer in court. Custody and visitation cases are cases that you may be eligible for a court-appointed lawyer. However, the parent must meet the income eligibility requirements. To qualify for a court-appointed lawyer in a custody case, a family of two must earn less than $45,000, just under $46,000. And you would bring in this information to your court case for the judge to determine whether or not you are eligible for a court-appointed lawyer. So now let's talk about guardianship. What is guardianship? Guardianship is really life decisions about health, welfare, educational decisions for a minor child. It's extremely similar to custody, but more people can file for guardianship. There's also a lot of different kinds of guardianship, and guardianship cases can take place in Supreme Court, surrogates court, and family court. Today, we're just going to focus on 4 different kinds of guardianship, and specifically guardianship that takes place or could take place in family court. So there's guardianship of the person or guardianship in family court. This would allow a guardian who is appointed by the court to make life decisions, health, welfare, educational decisions for a minor child. You have to go to court for this. There's something called standby guardianship, which would allow parents with terminal illnesses or parents at risk of deportation or removal proceedings to be able to plan for their minor children's custody when they're incapacitated or when they can no longer take care of their children. This is someone who is given temporary authority to care for another person's minor child. And again, you have to go to court for this. There's also something called designation of person in parental relationship. This you do not have to go to court for. This is a short-term solution up to 6 months, but it can be renewed every 6 months for parents to designate or appoint someone as a temporary guardian of their child. Both legal parents must sign off on this. So you can't have one parent doing this and the other parent disagreeing. It will automatically cancel out the appointment. There's also something called kinship guardianship or KINGAP. This is a resource for children in the foster care system to be placed with a relative guardian. Now, what's the differences between custody and guardianship? In New York State, there's very few differences, honestly. However, in other states, there can be many differences between the two. So if you're planning to move and you're considering custody versus guardianship, you should find out about the laws in the state where you're going. And this can help you decide whether you want to file or ask for custody or guardianship. So here's some common facts and differences between guardianship and custody in New York State. Custody can be changed if a substantial change of circumstances can be shown, but a guardianship can be vacated or terminated if the court finds that the guardian has failed to or is unable, unavailable, or unwilling to provide proper care and custody to the infant child, or that the guardianship is no longer in the best interest of this child. Now, in custody, immigration status is not required to file, but for guardianship, you must be a lawful permanent resident of the United States. Custody, there's no fingerprinting requirement, but in guardianship, there is a fingerprinting requirement for the entire household. And that's because the court, before making a best interest determination in a guardianship case, jurists want to have as much information as possible to ensure the stability, security, and permanency of this child. Fingerprinting can provide information on the criminal history of adults in the home that can be useful in making that determination. Now let's pause there for any questions about custody, visitation, or guardianship.
Thank you, Molly. We do have quite a few questions that have come in, so we'll do our
Great.
best to get to all of them. If we don't get to your question today, please feel free to follow up with us. Call our helpline at 212-343-1122. You can also visit our website at familylegalcare.org. And just a quick note, if you do have a question or additional questions, please try to use the Q&A feature. That way we can make sure we see them and address them. Okay,
Yes.
so first question is, can you explain the difference between joint and shared custody?
Sure. So joint custody is something that's ordered through a court. Shared custody is when there's no court order. That's the default, what everyone has before going to court. Joint custody through a court order. They're very similar. They sound very similar, and that's because they are. One is just ordered through the court.
Thank you, Molly. And we have a few questions about child support and visitation. So can you talk a little bit about that? Like, for example, if some non-custodial parents' visitation increases and they now have more parenting time, how does that affect child support?
So it generally doesn't affect child support. Like I mentioned before, custody and visitation and child support are separate cases heard by separate jurists. So even if you're spending more time with the child, you may not be eligible for a modification petition because they're separate. Now, it could be different if, let's say, you are now providing childcare and you were paying for childcare through the child support order. That may be a reason why you could modify the court order. But again, everything is so specific. So I would say give us a call if you have any specific questions about that, or you think you may be eligible for a modification. We can try to walk you through that.
Thank you, Molly. And could you talk a little bit again about grandparents and visitation rights? And so
Sure.
is it true that grandparents have visitation rights? And if so, could a grandparent seek assistance from family legal care?
Yes, absolutely. So grandparents do have the right to file a petition for visitation in family court, like I mentioned. And that is absolutely something that we could help with. So give us a call if you are looking for help doing that. Now, parents do sort of have that overriding say, but the court is going to be looking at, is it in the child's best interest to have this visitation, this parent, or this time spent with a grandparent or a relative?
Thank you. What happens if you started a case and you need to serve the other party, but you cannot find them or do not have their address?
That is a great question, and it's something we get all the time. Service is required before any case, and it's the responsibility of whoever is filing the case. So the court will not file or will not serve the other party for you. Let me start by saying that. Now, if you're having trouble locating the other parent, if it's an issue of child support and you're the custodial caregiver, the person who has physical custody, you may be able to reach out to the Office of Child Support Services, OCSS, and they may be able to help you locate the other parent or caregiver. What I often tell people is to look on social media, ask friends and family, but if it's really getting to a level where you cannot find them or locate them, you may have to hire a private investigator to try to track them down to be able to serve them. And the reason that the court needs you to serve them is because they need to have the other party notified of the case. They don't want someone to not be notified of any case against them.
Is there a difference between a judge, a magistrate, and a referee in a case?
Sort of. So a judge generally will hear cases, or the judges can hear all of the different cases. Support magistrates are generally hearing cases about parentage and child support. Court attorney referees are coming in to hear generally cases about orders of protection, which we'll talk about in just a second, and custody visitation cases. Judges, like I said, hear all of the cases.
Thank you. And then a couple more questions about child support. Is child support based only on the non-custodial parent's income? And would the court grant the non-custodial parent visitation rights, or would the non-custodial parent have to ask for those rights?
Really great question. So no, the child support order is based off of both parents' incomes. So both parties, both parents are going to have to present proof of both of their incomes to the court. Like I was talking about before, when you have to appear and provide that credible evidence, the financial disclosure affidavit, the pay stubs, income, tax returns, things like that, both parents are going to be required to do that. And the second part, can you reread the second part of that question for me?
Oh, sure. Would the court grant the non-custodial parent visitation rights, or does the non-custodial parent have to ask for the visitation rights?
They would have to file. So again, they're separate cases heard by separate jurists. The support magistrate will likely hear the child support case, but you would have to file a petition for visitation if you're looking for visitation. And that's going to be heard by either the court attorney referee or a judge. Really good question.
Okay, we'll do one more child support question and then we'll move on so we don't run out of time, but we'll try
Sure.
to get to the rest at the end. At what age does paying child support terminate? Can it ever go past the age of 21?
So child support will go until 21. However, if there are arrears that unpaid child support, those will never go away.
Thank you, Molly.
Sure. All right, so let's talk a little bit about family offenses and orders of protection. Now, you can get an order of protection in family court or criminal court, but there's different requirements for each. So in criminal court, it's called an order of protection. In family court, it's referred to as a family offense petition or case. Now, to file in family court, there has to be a relationship requirement. You must be related by blood or marriage, be married or have been married in the past, have a child in common, or be in or have been in an intimate relationship. Now, criminal court, there's not that requirement. It could be a stranger, but there has to be a criminal case, and you're not the person who is filing for this order of protection. It's the state, the prosecutor or assistant district attorney, ADA, is the person bringing the case to the judge, and it's usually after an arrest is made. Now, in family court, there is no requirement for an arrest, and you can have this completely out of family court if you want. Now, let's talk about visitation and family offenses and how they interact. If the other parent has a family offense petition against them or an order of protection, they may still be allowed visitation with the children. And this really depends on what the order says, if the children are listed on the order, and again, coming back to if it's in the children's best interests. Now let's talk a little about frequently asked questions when it comes to orders of protection. Can I file for an order of protection for my child? Yes. You can ask the family court for an order of protection that protects you or your child or both. Can my information be kept confidential? Yes. Fill out an address confidentiality waiver with the court. This will allow you to keep your address confidential. You can also ask the court when you have your hearing. Now, please know if your address is confidential, you need to keep them updated anytime you move. This is how the court will serve or notify you of any further court dates or anything that's filed against you in the future. Now, how long do orders of protection or OPs last? In family court, temporary OPs generally last until the next court date. Final orders of protection last for about 2 years, but it can be up to 5 years. Can I get a free lawyer? Generally, yes. If you're financially eligible, you can be appointed a free lawyer to represent you in your case. Now we have a list of resources if you need to or you're thinking about filing for an order of protection. The New York State Coalition Against Domestic Violence also has a great directory of programs by county where you can find out about shelters, counseling, referrals, and other services near you. And I believe that Jessica will put that link in the chat as well. All right, now let's open it up for any other questions that we didn't have time for before.
All right, thank you, Molly. So we have a question about filing and waiting for a court hearing. A client applied for child support during the pandemic and has been waiting for an appointment for months. What should she do?
So that's unfortunately the court is extremely backlogged because of the COVID-19 pandemic. They are working through their cases as quickly as possible. But what I would say is first make sure that the court has the petition and that they have a court date. And keep in mind that the child support is retroactive, meaning it goes back to the date that you file. So if it either needs to be established or if it needs to be changed, it's going to go back to the date that you file. So even if you don't have a court date for months from now, it's going to go back to when you filed.
All right, thank you, Molly. If I pass away and I put in my will that I want my daughter to get, that I want someone to get full custody of my child, would this be upheld after I'm gone?
Possibly. It's going to be something that the court may take into consideration, but it's not going to be the only thing that the court takes into consideration. They're going to be looking at things like, is there another legal parent involved? Any other caregivers, relatives? What you want is definitely a factor, but it's not going to be the only factor that the court considers.
What if there are complaints about the assigned counsel? Where does one complain to?
About the assigned counsel, I believe that they can make those reports to the court, to a supervising judge, but I believe that there's also a number. I'm not sure of that off the top of my head though. But
Yeah, I can jump in. So there is
yeah.
a way to submit a formal complaint about attorneys. There's a commission that handles complaints. If someone is not happy with their assigned counsel, they can request a new assigned counsel in court. So the judge or the jurist on the case would have to make that decision. It's not guaranteed. They would have to explain why they're looking for a new assigned counsel. But those are two options that someone may have.
Thanks, Jessica.
Sure. Okay, so we have another question about child support. I was under the impression that college payments or extensions of child support past the age of 21 are only for matrimonial or divorce cases. Is that true?
Generally, that's where you're going to see those come into play. But if two parents who have not been married do agree to that and make it a court order, they can extend that to extend the child support for college as well. But it's not automatically included.
Is there a penalty for constantly filing petitions?
No, generally not. But if this happens, what the other party could do is ask the court to dismiss the case with prejudice. And that would mean that they would not be able to file a new petition. This is not that common though. This is usually after a number of cases have been filed. What can also happen is that the jurist, if someone needs to file a petition in a certain case, then the jurist will review it first before it's sent out to the other party.
Thank you, Molly. How would a custodial parent navigate relocation if there is a safety concern, such as an order of protection expiring, or if they're escaping domestic violence with a current partner? Are there proactive steps that survivors can take if they are considering relocating?
Yeah, I would say, actually, I'm going to go back to this slide and say, reach out to any or all of these organizations. All of them are incredible for safety planning tips and resources. They can help you talk through what that could mean. You can also give us a call and we can talk about relocation specifically, what that means, but I would reach out to one or all of these organizations.
We have a lot of really great questions coming in, so thank you all so much for participating. Another question is about orders of protection. What if an OP petition had a mistake of limited request when actually a full OP is needed? Can the petition be changed to a full?
Yes. So what might be able to happen is someone could file an order to show cause, an emergency request of the court letting them know. But it really depends on where in the case it is, if there's been a final order. What I would say is contact the court for more information on this, or give us a call.
All right, another person asked, I filed child support during the pandemic and have a court date. I received 2 sets of copies, one with my name and the other with the non-custodial parent's name. What does this mean? Was that parent served?
Really great question. No, they were not served. So like I mentioned before, it's whoever filed. So whoever started this case in this instance, it would be your responsibility to serve the other parent. And what that really means is notifying them, giving them a copy of the summons and petition at least 8 days before the court date. Now, you cannot be the one to give them those papers. It has to be someone else who's over 18. And if you have, we have a really great LRG, legal resource guide, on service and serving court papers. You can also give us a call and we can talk through service and how to do that.
What if the custodial parent is refusing to adhere to a court-ordered visitation? Are there steps the non-custodial parent can take to enforce the order?
Really great questions, guys. Thanks for participating. You could file an enforcement petition, but if the non-custodial parent is not interested in having the visitation at all, then like I mentioned before, the court is not going to be able to force them to have this relationship with their child. But this could also mean that someone could need more childcare if the non-custodial parent is not complying with or following this court order. Then you may be able to file a modification for additional childcare. But again, really specific, and give us a call.
How does visitation work if both parents live in 2 different states, more than 8 hours apart? And how long does it typically take to get visitation rights?
It depends. Again, I'm going to come back to that. It depends. What visitation can look like is going to depend on what's in the best interest of each child. And because each child is so different, the court is going to look at each child individually and determine what visitation is going to look like. So how long does visitation take? The courts are backlogged for a few months. So if you filed a petition right now, you may not get a court date for a couple of months, but you may be able to start preparing for that court date beforehand. And again, I would say give us a call and we might be able to help you prepare for that or determine how to have that visitation in the meantime.
Is an 18B lawyer still on a case if they filed a motion to be relieved, but that motion was not yet granted? And if the 18B lawyer is not responding to emails or calls on a case before that motion is granted, what can the person do?
So technically they are still the 18B on the case until a judge or a jurist says that they are no longer the attorney on the case. Yeah, that's what I would say.
All right, one more question that I think we have. Hopefully we got to most of them. What do you do if family court and or ACS is violating your rights as a parent?
I would suggest reaching out to one of the defenders organizations. They're really the experts on ACS and child protective cases. And giving them a call and seeing what your rights are and how they can help.
Okay, I believe those are all of the questions. I know there are a couple more that I'm going to respond to directly in the chat or through Q&A. Are there any other questions before we wrap up? Okay, I think that's it. So Molly, if you want to turn to the next slide. And I will just say thank you, everyone, because that is the end of our webinar. Before we go, we just wanted to give everyone a reminder of how you can get in touch with us, whether you have additional questions from today's presentation, or maybe we didn't get to them because we missed them somehow in the chat. We apologize for that. Or if you just need some additional support or assistance with your family court case, or maybe you just want to learn more about what we do, you can reach out to our helpline by phone, 212-343-1122. Also by live chat or email. You can also visit our website to access our legal resources and our tools. And then please follow us on social media. I'll put all of this information again in the chat before we go, but this is how you can reach us. And then if you want to turn to the very last slide, I know this is what people have been eagerly waiting for, is information on how to get copies of the slides. So as we've mentioned in the chat, we will be sharing copies of the slides. We just ask that you give us a little bit of feedback on this webinar, and then in exchange, we'll give you a gift of the slides. So the link to the form for feedback is here. You can see it also, I'll put it in the chat as well. And we will be sending out a follow-up email with this link as well. We would love to hear from you. We want to know how to improve our program. And we hope that this was helpful to all of you and that you enjoyed it. And we also will be posting a recording of this webinar to our YouTube page, and the link to the YouTube page is here in the chat. So thank you all so much again. We really appreciate all of your attention, all of your participation, all of your amazing questions. Please reach out to us if we can do anything to support you or your clients. That's what we're here for. And we hope you all stay safe and healthy, and we hope to see you again soon.
Thank you all.